Okay, let's go on the record. Cause numbers 24 DCCR 0917, 0918, and 0407 on Dalton Batist. And sir, you're Dalton Batist?
Yes, ma'am.
All right, and Mr. Gertz, Mr. Kelly are here for Mr. Batist, Mr. Coleman's here. The first two indictments are murder, and then the last is for possession. There's been a motion to consolidate. Is that all of them, including the possession, or just the two murders?
Just the two murders, Judge.
All right, and so that's been on file, and you don't have any issue with that. So then I have, let me get it pulled up for the right one. With regard to pretrial issues, well, and you're both ready to proceed?
Thank you, Judge.
All right, Ms. Delays, you are free to go. Thank you. And is there anyone else?
He's outside.
Welcome to my channel Closed Case. Subscribe for more video.
Judge, may I ask you one question?
Yes, ma'am.
If I stick around and watch Mr. Gertz answer
No,
questions?
absolutely. And you can sit up here in the jury box, and if you need at some point to sneak out, you can just sneak out the back door. Just it'll be closed though. I'll make sure I see you leave
Somebody will sneak out.
so that they can come let you out of here.
Thank you very much. I'm gonna go let him know.
Yes, ma'am.
That was in my box with my court stuff.
Oh my gosh.
I feel like that is a thing.
Would you get Mr. Kimmler and his client, please? Y'all give me just a second because, is this you as well? We've got another untestable patch on Tejuan Mac.
You know the state's position on that, Judge?
Well, I'm
I
done.
think I had a motion on file.
I think we've,
Y'all have already had a hearing,
and
Yeah.
and you ordered him to
to
do
do it.
whatever it took.
Mhm.
This came
I did.
in on the 25th, it looks like.
Yeah. Get ready for somebody.
George.
I'm about to.
Did you want me to reach out to probation or you just see?
You don't see either of them?
You want me to
All right, did
text
you-
him or-
Would you go ahead and call the name, Tejuan Mac? And if you'll
He was here this morning.
text Mr. Kimmler, and I'll do what I need to then. And then I need to know what his current bond is set at. I might can figure that out.
Mr. Mack is present.
Okay. Let's see where, Mr. Mack, just have a seat in the front row right there, please.
I think Mr. Kimura had questions in Judge Stevens' court.
You want me to try to grab him?
Yes, please. And if I need to, I can run over there and just tell him real quick. I need him literally for 2 minutes. So it looks like it was 100,000 with a,
It's just steadily gone.
so it's 150 now?
The current one he's on is 100.
100. I think I raised it and then I withdrew a warrant
Okay.
the last time, I think is what happened. Recall, yeah.
Okay. That's lots. Yeah, I'm sorry, Judge, I see that.
I see that now too. While we are waiting on Mr. Kemmler, let's go ahead and do what we can, and then I might just need to break for a second.
He is not next door, Judge. I'm checking the drug court right now.
Thank you.
He's arguing with me right now.
He is,
I told him to come on.
okay. All right, so a couple of things. Let me get this pulled up right. Too many things going on. Mr. Batiste. Okay. For any pretrial that we need to take care of before jury selection this afternoon,
I don't recall if you granted or not the state's motion to consolidate those two murder cases.
She did,
I believe I did, but if not, that is granted.
and we're in agreement to that.
And that's to consolidate 24 DCCR 0917 and 0918.
And just for the record too, just our rationale, because sometimes you do want to object to that, but here, it's our position that this is a novel case, and these, whatever happened or didn't happen, happened to both of these same people at the same time, the same course of conduct and everything else, and so there's no rational defense strategy that I can come up with to object to that. So.
All right, thank you. The state filed a motion in limine.
It's a garden variety motion to limit. Judge, there is one thing I may want to just highlight with this particular case, is the notion of arguing in any way or form jury nullification. You know, that this, you know, with this being a new law, you know, just, I don't know if.
I'm going to get to that in just a second. Let's go through.
I've never argued that before, and I know that I'm not allowed to argue it, and so I wouldn't.
Well, and I
intend
think
on
there's
that kind
some differences in what we're going to deal with, because I think there's some difference in opinion as to how to read the statute, and there is no guidance
That's
on
kind of what I
that.
was getting at.
So I think there's going to be not necessarily obviously I'm not going to allow a jury nullification. Different reading of the statute, however, without any guidance for me, we'll talk about in a minute. So let's go back to the motion in limine that was filed back in 2024. Mr. Gertz, do you have any objection to that motion?
No,
The
Judge.
state's motion. So I will grant the state's motion in limine. Obviously, if either of you, if anything's covered, it goes, I want that to go kind of both ways on what's in there. You both know, just approach me. We'll take up anything that's included outside the presence of the jury.
There is one thing that just popped into my mind, judges. I don't know that it's appropriate for there to be even a discussion about this being the first time that this type of a case has been brought.
Hold on, let me get I'm still on motion in limine.
Yes, ma'am.
We're gonna get there. I'm printing that order on the limiting. Okay, I'm getting the easy stuff first. Second, I see that Mr. Gertz has filed a motion to suppress phone toll evidence. I guess it's based on, it looks like there was Detective Neal in his report talked about call log or call detail or phone toll, whatever you want to call it, and that there's no evidence of a warrant. Mr. Coleman?
I will concede that there was no warrant at the time when Detective Neal accessed at the scene during the chaos of the scene, the deceased victim's Matthew Crisis cell phone. He went into that cell phone and obtained the cell phone number for our deceased victim, and is that it's the deceased victim's right or standing to be asserted to that privacy interest, if it's asserted. Even more than that, Judge, after he obtained that cell phone number, he gave it to a DEA agent who ran the tolls. In other words, no communications were disclosed, or text messages or anything that shows the substance of those communications, just the numbers that called that number and the numbers that number called, the tolls. Mr. Gertz in his motion conflates CDR, cell phone data records, with toll information. And I would concede that cell phone data records that contain substantive communications, the actual messages, that's a whole different ballgame. But the witness who I will call, the DEA agent who analyzed those tolls, will testify that this information comes from what she calls public source information. In other words, put the cell phone number in, and the information that comes from consumer reports, Accurate, whatever those databases are, that's what pops up when they put that cell phone number in there. It's not an invasive search. And one last thing I'd like to add, Judge, is during this entire, there's that exigency portion, Judge, and the fact that the toll records don't produce any substantive issues, and also, or communications, and also the standing that this defendant lacks with regard to the deceased cell phone. And lastly, Judge, I would argue inevitable discovery. Almost simultaneously, ID shows up at the hospital and photographs the contents of my deceased victim's wallet, which include, and we have photos that we're willing to offer in evidence, a photograph of the defendant's, the victim's business card that has his name clearly printed, and it says on his business card, cell phone number, and it lists the cell phone number. So just in the alternative, I would argue that it was inevitable that law enforcement was going to get that number and use that cell phone number to get the toll messages, to figure out who was communicating.
I guess let's start.
May I clarify?
Hold on. I just want to start at the beginning, because if there's no standing and there's no one to argue, I guess let's start at standing to file the motion.
I don't care about Matthew, is who he's talking about. I don't care about Matthew's cell phone information. That I certainly think was inevitable discovery, and even if it weren't, they went and got a warrant for his actual cell phone. They, as quickly as they could, they went and got warrants for the two boys that were in the hospital, one of whom eventually died, and the boy that died at the scene, the young man that died at the scene. Not talking about those issues. My issue is Detective Neal gets a hold of the phone number and somehow starts in his report. You see him switch over and says, Dalton's phone is at this location from this period to this period. That's what I'm objecting to, because there's no warrant for that. I don't care about Dalton's phone number called this phone number, because they could get that off of another cell phone. Got it, no problem. My complaint is about CDR location, and clearly from his report, Detective Neal had that information and did not have a warrant for my client's information. And it's very narrow what I'm talking about.
Yeah, if there's any information about the defendant's location from a phone.
Not in the toll records, Judge.
It's where Matthew Neal says he got them.
Well,
and there's no other records.
I'm not going to elicit that testimony from Detective Neal, but at the juncture when I put on Carmen Morgan as the DEA agent who analyzed the toll records, all I'm getting out of her is what numbers my deceased phone called and what numbers called his phone.
So
her testimony.
So with regard to specifically any information that was obtained about the defendant's whereabouts based on a phone search, were there any warrants? Not warrants. Were there any search warrants done on the defendant's phone that would give that information?
Ultimately, yes, ma'am. And I'll put on testimony. I plan on putting on testimony pursuant to the search warrant that we obtained.
The search warrant that we're talking about that ultimately got to his phone was long after he had said, he's at this location, he was here this long, we know he's the guy, and that's how they zeroed in on him. Now, it was the conversations, but the big problem is there's a real specific time and location, and they had access to that, and they got that information illegally. And so, warrantlessly, let's call it that. And so, if you read the chronology of Detective Neal's report, that's my problem, is he's saying, well, we know it's Dalton and not the cousin, Howard, who was really the conduit for all this. We know it's Dalton because Dalton was at the address where this occurred. Well, that was before Dalton was picked up. It was before his cell phone was in hand.
The office report the report may read that way, Judge, but the toll information could not have given location data.
So we're talking about two different things.
Yeah.
So the toll information is going to, according to you, is going to come in and say, calls in, calls out, not
I
substantive,
don't have any
anything like
objection
that.
to There's no problem with
And
that.
that was obtained from the decedent's phone.
Right.
Right, and I don't have any objection to that at all. I'm not,
Well, that's what the
no.
motion to suppress says.
I'm sorry. So I think Detective Neal is using the phrase phone tolls, and I think he's wrong. Phone tolls is something we used to have back in the day where you look at just the call logs.
So here's what I'm going to say. If there was any search of Mr. Batist's phone prior to, or not just his phone records or location or anything like that, prior to a warrant being signed, search warrant being signed, then any evidence of anything that happened before a valid search warrant is off limits. And so with regard to that specific issue, I'll grant the motion,
And that's all we're at.
but very limit to anything that came off of Mr. Batist's phone prior to valid search warrant.
Yes,
Okay. I'm gonna need to probably figure out how to,
And then Judge, I'll say if there's other evidence.
I don't see an
location-
order,
Sorry?
I don't see an order for this motion. I'm just gonna write on the front page. I don't see that there was an order filed with the motion to suppress. Give me just a second. If I just do it on the front page, you can, okay.
Whatever you want, I will make happen.
Okay, the way I just wrote this was I granted the motion specifically with regard to any location data received from the defendant's phone prior to a valid search warrant. Is that clear
Yes.
enough? Sorry. Okay. It looks like there was a certificate of analysis filed. There was an objection to that. That looks like it was timely filed.
I'd like to address that if I could, Judge.
Sure.
There was actually 3 certificates of analysis filed in this case, 2 of which were filed some time ago and relate to the lab blood work on my 2 deceased victims. Those, as I understand it, are and remain unobjected to. I recently filed a certificate of analysis with regard to some punishment evidence, if we get there, on the possession of marijuana. That's a felony case, the felony complaining case that we have. And I will concede that Mr. Gertz timely objected to the possession of the marijuana certificate. In fact, he specifically referenced the lab analyst who did the analysis.
Okay. So it looks like there was one filed back, a certificate of analysis, June 20th of 2024.
Those are just the NMS. lab.
NMS and
You don't have any issues with those?
RUP labs, Judge. Just want to make sure
Okay.
that we're
But
clear.
those are autopsy-related,
Yeah.
heart blood. So
Okay,
I don't
so
care
y'all are
about
on the
that.
same page as far as that goes. I just want to make
Yeah,
sure.
I guess I didn't look carefully enough at Mr. Coleman's subsequent certificate. I was anticipating it being a certificate for something, a physical thing that was found.
Okay.
So,
So we're on the same page as that. I have election as to punishment that's been filed if there is a finding of guilt for the jury, correct?
yes, Judge.
All right, so then I have the issue with regard to Mr. Gertz has filed a bench brief regarding the mens rea in this case. I've done some of my own research. Mr. Florence has done some research. I think we're all in agreement that some of the issues with regard to mens rea and specifically how it applies to the specific statute with regard to fentanyl murder. I think there's probably some disagreement on. There is no case law. There is nothing for me with regard to stating what, I guess, I may have my own personal feelings, but legally what it means. So here's where I am on that. I don't believe that it does any good to discuss with the jury that this is a new law. And so I am going to, on my own, limiting both of you to say that we're not going to say this is some new case and we don't really know and y'all get to decide and whatever. It's, the law is going to be what the law is. Y'all know how I do my charges. I take things straight out of the code. I'm not inclined to deviate from that. What I'm not also inclined to say now what I'm going to do later in the week in a charge. A lot of that depends on evidence that's presented throughout the case. I understand that which part of the knowing definition I put in could matter, but I don't, and I know you had mentioned that there's three. I don't know that I agree that there's three options. I think there's two options, but I have had cases, and y'all all know I've had cases where I put the first option, I put the second option, and there are cases where I put the entire definition. And so I think those are things that we take up at the normal time.
That's fine. The reason I did this was I wanted to put it out there so we can be discussing it, Judge, because I think that, to me, the biggest issue is going to be, it dictates how we try this case. If it's going to be a strict liability thing and I just happen to sell something and that something happened to have fentanyl, and then, well, there's that word is meaningless then. It might as well just be an act and a result. And
I mean, I can,
so I guess the point I'm making is,
yeah.
I'm saying, I'm not trying to launch into an argument. I'm saying it makes a difference in how we try the case. Not necessarily the three options. It makes a difference if it's strict liability or not. And I don't think you're going to find anywhere in the code that it says.
No.
Well, Judge, if I could respond really briefly.
Sure.
I think a plain reading of the statute is all we need, Judge. It simply says knowingly deliver fentanyl or substance containing group 1B that results in the death of an individual.
I agree with that for the charge.
The straight definition of knowing and intentional means consciously engaging in that conduct.
It
The
does
conduct
not.
of delivery.
It means all three of those things. I spent a ton of time on this weekend. This Texas Court of Criminal Appeals lays out what the three things are, and they're just different from each other. And I never thought about this, as I told you before. I'd never thought about them being three instead of two, but it really is three, and they really mean something different.
Well, intentional,
Intentional is not an issue.
it's not an issue.
Well,
Knowingly is the issue.
Knowingly is the issue, and whether or not the statute reads that the defendant knows or had knowledge that what was delivered or manufactured had fentanyl in it or not. My reading of the statute is that, and not just my reading of the statute, I have legislative history that I have looked at and Mr. Florence has looked at. I don't believe that in my opinion, that they would have created a whole fentanyl murder statute without the requirement that the defendant had knowledge that it was fentanyl. That's where I'm coming from on this. I understand that there is a difference of opinion, but I don't think it's appropriate necessarily for me to make that call. I think the definitions and the statute says what it says. And the problem is, if I put the entire definition of knowing, I guess that is where you guys will run into issues, is which definition, if it's the first part, the second part, or both.
And this is the last thing I'll say with the court's permission, Judge, is
Sure.
I think the knowingly goes straight to it modifies or goes to the word delivery. It's the knowing delivery of this substance that contains fentanyl.
Well, but you don't get to stop the sentence at deliver. Knowingly, the whole rest of the sentence is knowingly deliver a substance, not knowingly deliver any substance, knowing
Yeah.
it.
I apologize, Judge. he delivers a substance that is an illegal substance. He just has to know it's an illegal substance.
No, he has to know it's fentanyl. It is specific in fentanyl. Then why are we going under the fentanyl murder statute? Because it says under Health and Safety Code, specifically, it's a very specific new rule that they created that says that he knowingly manufactures or delivers a controlled substance included in, and that section 481-1022 is just fentanyl. It's not any substance that contains it.
But we're not
It's
proceeding under
fentanyl.
we're proceeding under 1902B4.
Which reference is that?
That is
Penalty
that.
group
That
one.
is the fentanyl
That's the
statute.
fentanyl, but it's in murder. It doesn't show that he has to know that fentanyl was in that. He just has to know
It
that
says
he
he had-
delivered an illegal substance. Because
No, it says specifically, knowingly manufacture or deliver a controlled substance included in penalty group 1B under section 481-1022. 481-1022 is only fentanyl drugs. It's not deliver any drugs. It's right. You can look at it. It's got all kinds of acetal alpha methafentanyl, afentanyl, alpha methathiofentanyl. It's all
high-end opioids.
fentanyl. It's not cocaine. It's not delivered something. It is delivered something that a controlled substance in blah, 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 in a person. And then it says, it doesn't matter if it was used by itself or with another substance, including a drug or adulterant or diluent. So it could be in something else, but it says specifically, knowingly manufacture or deliver a controlled substance included in.
Just the practical effect of that would be, of that interpretation would be that any defendant can just come in to court and say, I didn't know it had fentanyl.
Well, and that's where, in my opinion, evidence that they knew would be probably required.
Which we don't have to prove anything.
No, you know what I mean? I mean, there are, if there was, for example, in the case we had, a month or two ago, there was evidence that the person, of course, that was under the old law, and I think it was manslaughter or however, I can't remember now, but there was specific evidence that he knew that there was fentanyl in it, and that that's what they were going to get from in that case. So I think it's different. So I understand, but here's the thing. I don't want, regardless of all of that, what my thoughts on it, I don't know are that important. My thought at this point is I'm going to let you guys argue it and figure out what the jury thinks. I don't know that I am planning to be the judge that says, I think this statute means a certain thing, and then specifically charge anything other than what the definition is in the code. And so the only question is the knowing definition and whether or not I include the first part, the second part, or both. And I know that changes how you potentially handle your case, but I'm not inclined to make that decision at this point. I think that's something like all charge matters that I will make when we're working on the charge, regardless of what I think. I'm not going to hamstring you on what I think or you on what I think. I believe it's potentially my job to do that. But I'm going to let it play out, and then I will determine what, and you guys at certain points can, I don't know that I'm opposed to you saying that we disagree what the law means, and it's, and then I'll tell the jury they're going to get the court's charge, and they will make that determination on what the facts prove and if it follows the law that's presented in that charge. So really the only question is the knowing, and I'm just not prepared to make that decision at this point. Okay?
Okay, thanks, Judge.
Okay. Anything else pre-trial?
Judge, I brought back the co-defendant, for lack of a better term. I mean, the what I call the go-between, Mr. Howard Celestine, that I submit to the court to set up this whole transaction. I bench warranted him back from TDC, and Laura Peraza was his original attorney. I emailed Peraza like last week. I haven't heard back from her.
She's in trial this week.
Troy tried to get a hold of her.
I did get a hold of her. She said she'd call me.
The reason I think she needs to admonish him about, his rights, not to incriminate himself. Also about perjury. too, so.
When do you anticipate his testimony?
Tomorrow.
Is that on my lap?
Yeah, tomorrow, late,
Very well could be
or Wednesday morning.
late tomorrow or Wednesday morning.
So let's have him, that witness here tomorrow when we get started, let's say by 12:30, if y'all can work on, George, if you'll get that done. And then even if is she in trial here locally or somewhere, another county? Do y'all know?
Hey, Mr. Coleman,
Yes.
Where's Rife?
we were aware that he was brought back. I'm not sure how we were aware, but somehow we were made aware that he was brought back here. But I don't, maybe I'm just blind. I'm not seeing him on the witness list.
I'm sorry, I was,
Oh, there's a second amendment one? Well, that would be important. Okay. Maybe we should pull up the right one, Gertz.
which one are you talking about?
Mr. Celestine?
What,
I believe so.
okay. So do we know where she's in trial?
Okay.
I do not, Judge. She said she'd call me at 4:30. That's a text message I received from her. So
Okay.
I'll speak with her this evening.
If you'll include me and the attorneys on a text after you talk to her, and then I will talk to her about if she's in trial here, we can just get her to run over. We can put something on the record right at 1 o'clock before we get started so that that's done. If she can't be here during his testimony, we can go ahead and have that done. Would that be enough, you think, if we do it then prior to his testimony?
Sure, Judge. I believe so.
Okay.
And there's one other thing. Oh, I emailed Mr. Gertz about redactions to bottom one camera so that we could, maybe expedite that.
Yeah.
Okay.
I want to talk to you about that maybe in the morning. We're having some.
Judge, it's going to be my first witness.
Okay.
Okay.
Cross is going to be your first witness?
My plan, yeah.
Okay.
So y'all talk
We'll
about
deal
it this afternoon before you leave and tomorrow morning, so that if I need to be doing something and watching anything, y'all know
I know.
and if we need to have the jury come a little bit later, I'd rather tell them that today. So I want to, y'all think about that real quick and get it worked out this afternoon after jury selection, please,
I think that's all I have.
or in the morning early. Okay. Anything else pre-trial then?
I don't think so, Judge.
Okay. As soon as Mr. Kimler walks in, did you text him again and find out how far out?
To see how far out he is and he has a blue flag.
Here's this.